How old do you need to be to start setting up a living trust? Well, it's really not so much about age as it is life circumstances. My name is Michael Pevney. I'm an estate planning lawyer. I create estate plans for California families. And in this video, we're going to talk about the three major life circumstances where I see people starting to have a need to set up a trust. But before that, if you have any questions related to this or anything else related to estate planning or probate, ask a question in the comments. Follow me for more estate planning information. And if you live in California and it's time to get that estate plan set up, you can set up a time to meet with me for free. My web address and directions are in my profile and the description to this video. So when do we need to start thinking about setting up a trust? Is a trust only for the super wealthy? The answer is no. So where I practice in California, there's a good chance that about half of the adults need some sort of a plan revolving around a trust. I'm going to get to what is an estate plan in general a little bit after this and why really every adult needs one. So the first criteria I see people starting to have the need for a trust is when you own real estate, whether that's a primary home or a rental home. And the main reason is because we want to avoid probate. Adding a home or a piece of real estate to a trust means that it will not have to go through probate. If you know somebody who's ever been through probate or you've been through the probate process yourself, you probably know that it's not very enjoyable, especially if you live in California. It takes a long time, it's very costly, and there's not a lot of privacy or control that you have over the process. The government controls it. A judge has to sign off on every little thing, and it's a very long process. So what we do instead of having the home go through probate, and by the way, if you have a will and the home passes to kids or whoever it's supposed to pass to by way of a will actually has to go through probate as well. Now, yes, you get to control where things go and who's going to inherit things, but it still has to go through this court process. It doesn't make it much shorter. Oftentimes takes a year and a half to 2 years. Oftentimes costs, well, really not you because you'll be dead, but it costs the ones that you leave behind somewhere in the range of about $50,000 on average for the average California home, the average type of client that I see. So we want a trust to put real estate inside of a trust so it completely bypasses, completely avoids this probate process. And that's kind of person number one that I would think of that might need to start thinking about getting a trust. It smoothly transfers things to the next generation or to wherever you want things to go. So if it's a primary home, if there's rental properties, you can put them all in a trust and things pass along smoothly. The second group of people I think that need to start thinking about getting a trust is anybody that has kids under the age of around, I'm going to say 25 or 30, or has anybody with special needs that depends on them. That's because a trust gives us control. It gives us control over our assets first, of course, while we're alive. Most trusts that I set up for people are revocable living trusts. That means that while you're alive, you have total control over these things and everything in them. You can change it, but once you pass away, things are a little bit more locked down, so to speak. But you also have a lot of control in setting things up. So say you have a couple of little kids, they're 3 and 5 years old, and you want to make sure that they don't start inheriting things, getting your legacy. Maybe you've got $1 million life insurance policy, your home's worth several $1,000s, you have some retirement accounts, that sort of thing. Parents pass away. Do you want these kids inheriting that as soon as they turn 18? And the answer, well, for me, I don't know, how would you have handled stuff if you inherited a lot of money and real estate as soon as you turned 18 without any strings attached? I would not have handled it well. So what a trust does is it gives us control over this property. So we can make sure that kids don't inherit things until they are responsible enough to inherit things. So some people say, you know, the frontal lobe of the brain, the decision-making ability doesn't really mature until maybe someone's 25. So maybe you want to wait until they're 25. Maybe you want to give them smaller amounts until they're small amount when they're 25, more when they're 30, more when they're 35. that sort of thing. Or you can have a third party, the next trustee, watch over these assets without anything specific amounts or chunks of money being put in their name, but the trust must be used for their basic needs, their health, education, maintenance, support. It can pay for college, it can pay for a car, it can pay for basic living expenses, and we can put all sorts of terms on that trust that they need to be living, a healthy lifestyle, or we're encouraging them to get an education or start a business or get a job, that sort of thing. And then in addition to that, people that have younger children or young adult children, anybody that you're caring for that has special needs, including a child, an adult child, or even a third party adult that depends on you. Because we can put very specific terms in that trust that's going to say both, going to give them access to your legacy, make sure that the trust can pay for certain things while also at the same time making sure that they're also entitled to any government benefits that they were otherwise receiving. Putting a huge chunk of money into their name may put those benefits in jeopardy. So the second group of people, anybody that has younger children or anybody that has special needs that depend on them. The third group of people that need to start thinking about setting up a trust, business owners. And yes, if you own a rental property, you are a business owner, whether you like it or not. And a business, much like a home, actually has to go through the probate process. And even if this is a business that you run and you can sell, if it has to go through probate, at least in California, that business has to be valued. It costs money for a business to get through probate, but the real problem is most smaller businesses, they kind of shrivel up and go away and lose all of their value, because if this is a smaller business that you are running and you're gone, there is nobody that's able to make payroll or make business decisions, that sort of thing, if this is having to go through probate. A judge has got to sign off on all of this stuff. Sometimes that takes months and well over a year. So if people aren't getting paid and the business isn't able to make any deals or that sort of thing, or there isn't a very well written succession plan written into the incorporation documents of this business, oftentimes that business just goes away. So what we can do is we can actually put a business in a trust. Typically, we can put the membership of an LLC, we can put shares of a corporation into a trust, and the trust says what is supposed to happen when the person that set up the trust is medically incapacitated or they're gone. So those are the three types of people that need to set up, in my mind, typically when we need to start thinking about setting up a trust, right? Property owners, people that have kids and special needs dependents, and business owners. But that doesn't mean that you don't need an estate plan until you reach one of those or aren't in one of those conditions or aren't in one of those, fall into one of those categories. Everybody needs some sort of estate plan. Every adult needs something that for them set up that needs usually three main documents, okay? The first being a power of attorney, a financial power of attorney. So if you are unable to handle your finances, you're unable to pay the bills, you choose who gets to pay the bills on your behalf, who's able to make financial decisions on your behalf. And you want to take it to take effect now, while you are okay, then maybe it's a matter of convenience. You want somebody to help you do the banking, or maybe you only want it to kick in to take effect when you are medically incapacitated, a springing financial power of attorney. The second document is a healthcare document, and it's essentially a healthcare directive. In California, we call it an advanced healthcare directive, and that combines with it two different powers. First, you tell people ahead of time what your end-of-life decisions are. The simplest way to put it is, do you want them to pull the plug or not? You make that decision ahead of time, it's signed, it's notarized, it's kept in a place where people have access to it, and your wishes are known. We don't want any confusion in that hospital room. The second is that it appoints a healthcare power of attorney, different than a financial power of attorney. Healthcare power of attorney makes healthcare decisions for you. You can name a primary person, you can name an alternate person. Sometimes in some states, these are split up into two separate documents. In California, it is one document, an advance healthcare directive. And the third document is a very simple will laying out who wants to get your stuff. Because if you don't have a document, whether it's a will or a trust, saying how you want your property distributed, the state is going to use the laws of the state to choose where those things go. And it's specified, there's spouses and children and parents and brothers and sisters and that sort of thing, but we usually want to be able to control that for ourselves. So we want a basic will laying out where we want our stuff to go. To set up a plan like this, it's relatively simple. And while I don't necessarily recommend do-it-yourself estate plans, most states publish the actual official state documents that you can create your own, each of these three documents: power of attorney, healthcare directive, and a basic will. Sometimes it's the state secretary of state. You can kind of type in the name of your state. I know that California does it, and that's something that you're able to do. But that's when it's time to start thinking about setting up a trust, which is, yes, it is a little bit more advanced estate planning. I do not recommend that people try to do this on their own or go through a sort of fill in the blank do-it-yourself service. When we buy a home, own real estate, have little kids, or anybody with special needs that depends on us, or own a business. So thank you for watching. Once again, my name is Michael Pevney. I am an estate planning lawyer in California. While some of this, even if you're out of California, may be very relevant to you, a lot of this information crosses state lines. Things are particular to California sometimes. And ask an estate planning question in the comments, and follow me for more estate planning information. And if you're in California and you don't have that trust set up, and you do have a home, and it's going to go through probate, and it's going to cost $50,000, if it's not put in a trust, you can set up a time to meet with me for free by going to my website, ocestateplanlawyer.com. Find a link in the comments. Thanks for your time, and thank you for your attention.